As a general rule, theft is bad. And I think we can all agree when our government does it, it's even worse. Well, the practice of civil asset forfeiture allows law enforcement to take property and cash from citizens, even without them actually being charged with a crime. Asset forfeiture began in 1986. While the idea might sound like the plot of a Training Day movie or A Place Beyond the Pines, it's pretty real. In 2017, the Department of Justice's Asset Forfeiture Fund took in $1.6 billion. And in 2014, it was a whopping $4.5 billion. The practice is used by the DEA, FBI, and other federal agencies during the process of investigations. It is completely legal thanks to the federal code and has even been upheld by the Supreme Court. While certainly, one could understand why law enforcement might need to take assets in cases where they are important in the scope of an investigation, and we might understand that forfeiture began really as a way to pursue stronger cases against organized crime during its heyday, it seems to have become a subject of abuse and really just a way for agencies to rake in money. The worst part of all this is that you can be innocent, have your assets taken, and never see them again. The Supreme Court has even said that the Constitution does not require you to get your assets or money back. To make matters worse, Attorney General Jeff Sessions said the Justice Department plans to develop policies to increase forfeitures. And earlier this year, he reversed a 2015 policy then Attorney General Eric Holder issued that prohibited local law enforcement from circumventing more restrictive state civil forfeiture laws by partnering with the feds. Listen as he explains.
Tool that helps law enforcement defund organized crime, takes back ill-gotten gains from them, and prevent new crimes from being committed, and weakens the criminals and their cartels. It weakens the criminal organizations when you take their money, and it strengthens law enforcement when we can share it together and use it to further our effort against crime.
When signaling this policy reversal, Sessions proclaimed no criminal should be allowed to keep the proceeds of their crime. The only problem is that we're not talking about just criminals. Take Tan Nguyen, who jumped in his car excited about $50,000 in casino winnings that he just won. That excitement faded when he saw police lights in his rearview mirror. A Nevada police officer, suspicious of the man's large sum of cash, confiscated it, according to Forbes. Nguyen said the cop threatened to seize and tow his car if he spoke about it. He eventually got his money back, only after having to pay for a lawyer. A New Jersey man, George Rebbe, had his stash of cash taken away by an officer when he traveled through Monterey, Tennessee. Rebbe had $22,000 of cash in his car, and he was stopped by a police officer, according to News Channel 5. The officer took the money because he suspected it was drug money. However, the man said he was going to use the money to buy a car for which he had an active bid on eBay. Something he was able to prove with his computer. When the officer wrote up the report, he failed to mention Rebbe's claim that he was going to buy a car completely. The likelihood of this changing is hard to tie down. The Supreme Court will be hearing a case soon regarding the practice. The case of Tyson Timms, who was forced to forfeit his $40,000 Land Rover in civil court to the state of Indiana after he pled guilty to selling $200 worth of drugs. Last year, U.S. Representative Tim Walberg and U.S. Senator Rand Paul reintroduced H.R. 1555, the First Amendment Integrity Restoration Act, or FAIR Act. It's a bipartisan legislation to curb asset forfeiture abuse and protect the American people's due process and privacy rights by focusing on the IRS. Another bill, the Deterring Undue Enforcement by Protecting the Rights of Citizens from Excessive Searches and Seizures, or Due Process Act, H.R. 1795, was introduced by Representative Jim Sensenbrenner. And the Due Process Act includes changes to federal forfeiture laws that fail to protect innocent Americans. The Due Process Act would raise the standard of proof required to deprive citizens of property from a preponderance of evidence, which is a low standard that merely requires a 51% likelihood that the facts presented are true, to the highest standard in a civil court called clear and convincing evidence. Additionally, the bill places a burden of proof on the federal government, strengthens protections for claimants by requiring a right to counsel in civil asset forfeiture cases, and makes it easier to recover legal fees when the property owner prevails in court. It also increases accountability and transparency by requiring a yearly audit by the Inspector General. You can find both of these pieces of legislation on Daily Cloud's BillCam. Thank you for watching Iziah Explains. I'm Isaiah Thompson. I'll see you next week when Congress is back in session. Please comment below. Tell us how you feel about such policies. And if you want me to explain another policy or law that you care about, please let me know. Also, please don't hesitate to subscribe. And if you really like the work we're doing, like our video or go to our Patreon and become a patron.